Hey guys, how you doing? This is Joe Ott here, and I am here with my friend Max Groswald and my associate attorney Mark Blankenship. And I am an attorney here in St. Louis, Missouri. We have a nationwide litigation practice with an emphasis on civil litigation and have had a lot of good recoveries in different areas from ERISA, obviously personal injury and that type of thing, and on contract disputes and that sort of thing. And we're coming today, we want to start this podcast where we're going to give cutting-edge legal advice from sophisticated attorneys that practice and try and deliver take-home information that people out there can use in their own lives and just to gain a better understanding of the types of situations that they might be going through. So we were having a conversation here before, just trying to kind of get to know everybody. And so, Max, why don't you tell us how long have you been in practice for?
Sure. So I've been practicing for 7 years. I graduated from St. Louis University in 2013. I've been on my own for about 2 years now. Yeah. But I've been doing strictly bankruptcy for roughly 5 years. So that's all I do.
Yeah. So Max is just a genius when it comes to the bankruptcy stuff. And he's been working with us a little bit on some of the bankruptcy litigation that we're getting into because basically, you know, there's a lot of people out there that are going through issues with bankruptcy where they're having debts that are getting discharged and that type of thing, and they don't know what to do about it. So we're going to go into that a little bit later today on the show. And then we're also talking, obviously, with my associate here, Mark. And Mark helps us with all of our case types and has proven an invaluable resource. Just this last week, we filed a Washington, D.C. defamation action, and Mark was very helpful with the research and drafting for that. Mark, where did you go to law school?
Hey, Joe. So I graduated law school in 2019 at the University of Kentucky College of Law, which they changed their name to the J. David Rosenberg College of Law.
Okay.
And then I am currently an LLM candidate where I'm pursuing a LLM Master of Laws remotely at the Benjamin Cardozo School of Law at Yeshiva University with their new recent LLM program that they started online. Okay. Since the pandemic happened.
Okay, cool. And that's in intellectual property, right? With the focus?
Yeah, it's just with an emphasis in intellectual property. So so just for a couple of classes I've been taking internet law, cybersecurity, internet. I already said internet. I'll be taking patent and IP business transactions as well as privacy law. Okay. So it's a wide array. So yeah.
Cool. And then I've also got my friend Chris here. So Chris is from this is Chris Wills. He's associated with the Full Circle Music Group, and the Full Circle Music Group provides advice and services to artists and record companies throughout the country. There's about 20 or so affiliated artists already, and we're looking to grow that practice, so basically later today we're going to talk with Mark a little bit about some of the intellectual property litigation issues that he's been coming up with, and in future episodes we're going to have artists come on the show and give a rundown of the various rights associated with their creations, and then also just general business development and strategy to get the business off the ground. So let's go ahead and talk with Max here a little bit. And we're going to start off just talking about just generally bankruptcy. So Max, what is bankruptcy?
So bankruptcy is a form of debt relief that's in the United States where under certain circumstances, if you were basically in over your head in debt, you can, for the most part, petition a federal court and ask them to wipe out your debt for you. So there's various types of bankruptcy, and first off, it's important to understand a lot of people when they come into my office, they carry this kind of grief or shame, and I want to emphasize to folks out there, if you or someone you know is considering it or has considered it or has actually filed, there really is no shame in doing it, and if you go back to the founding fathers, not to get all cheesy, but it actually is in Article 1 of the Constitution. So there's Article 1, 2, and 3. Article 1 deals with congressional authority, and it actually says in there that Congress has the authority to establish bankruptcy laws.
Yeah.
So this is back in the 1780s.
Yeah, and so we've been working on a bankruptcy litigation case right now, and I've learned a lot about the bankruptcy process, and what you're saying is 100% true. I mean, basically, this is one of the things that really separates the United States from other countries in the world. And this was, at the time of the founding of the country, people were getting thrown in prison for debts. And nowadays, bankruptcy, you get people like Elon Musk, who's declared bankruptcy multiple times, right? And basically, it's something that is a very powerful asset. So if you're struggling, so what are some options for people that are struggling, Max?
Well, there's various types of bankruptcies that folks can pursue depending on their circumstances. So the standard default option that most people think of is the Chapter 7. A Chapter 7 is generally for individual consumers. It's roughly a 90-day process from start to finish. So what would happen is you file the bankruptcy. Let's say you file your bankruptcy today, May 7th. What would happen is approximately 30 days from today, you would go to court, you being the consumer plus your attorney. You testify in front of this person called the Chapter 7 trustee. And the Chapter 7 trustee is kind of like the referee between you and the creditors. The trustee asks you a whole bunch of questions under oath about all your stuff. Did you list all your assets? Did you list all your debts and list all your creditors? And their goal is to basically see if they can take any of your assets and liquidate them. That is, turn them into cash, and then use that cash to pay off your creditors.
Okay, and a creditor means somebody that you owe money to.
Correct. Okay. So a creditor can be anyone. It can be your American Express credit card. It can be a medical bill. It can be a deficiency balance on a car note, anything like that.
Okay. So what you're saying is basically you could have hundreds of thousands of dollars in debt, and if you apply for this process, the debt can basically go away. Is that right?
Yes, and honestly, it almost sounds too good to be true. It is not. You honestly, for depending on the filing fee and the attorney's fees for $1,000, $2,000, depending on the totality of circumstances, in approximately 90 days, you can go from hundreds of thousands of dollars of debt to $0 in debt. I filed, for example, a couple of different business bankruptcies recently where, a few guys, they took a risk, COVID hit, and the business didn't work out. They had hundreds of thousands of dollars in debt on various business loans, and the chips just fell, and it wasn't in their favor, and they filed for bankruptcy. And again, that goes back to the vision of the founding fathers, which is in order to have a free market economy and to thrive in a capitalism society, it's important to have that safety net. Because otherwise, if you take a risk and you fail and you're permanently stuck with that debt, then entrepreneurs are not able to rebuild themselves and take further risks down the road.
Okay. So now, is it different process if you have if you're a person versus if you're a business in terms of getting the debts discharged?
It is. So generally, a Chapter 7 is only for individuals. For the most part, corporations cannot file for Chapter 7 bankruptcy and receive a discharge. So for companies, whether it's businesses, LLCs, corporations, whatever it is, oftentimes you either just file the Chapter 7 and you abandon the business, or you can file a Chapter 11, which is basically a workout. So, for example, back in 2008 or 2009, when the world economy crashed, you heard about General Motors and Chrysler filing for Chapter 11 bankruptcy, which is basically a way to restructure their debt.
Oh, okay. So that's what you hear about when people are saying they're reorganizing.
Precisely. So whenever you hear about big businesses filing for bankruptcy, oftentimes it's Chapter 11s. That's correct.
Okay. All right. Well, so the bankruptcy process is super beneficial for people that are going through it. Now, it also it can be kind of harsh for people that are owed money. So if you're in a situation where somebody owes you money and they go through bankruptcy, they're in a bad place, pretty much, right?
Right.
Yeah. But there's also certain types of these bankruptcy debts that are not going to be discharged, and this is where Max and I are developing our business and bankruptcy litigation practice, because we know that there are people out there that are owed money from people going through bankruptcy, and there are certain situations in which you can still recover that debt if you have the right attorney and you go through the right process. And in particular, we're looking at Section 523 of the Bankruptcy Code. So why don't we talk a little bit about some of those exceptions?
Sure. So first off, let's just, to make sure that we're on the same page, when we say the word discharge, discharge means wiped out. So for the layman, discharge basically means your debt is just gone. It's kaput. All right. And Joe, you're absolutely right. Now, if you were a creditor and then you receive notice that somebody who owes you money files for bankruptcy, not all is lost. There are certain circumstances under which you can prevent that individual from wiping out your debt.
Yeah.
And so what basically, it depends, it's very fact intensive, but there is the bankruptcy code, so I did bring my bankruptcy code book.
Which he carries everywhere.
Yeah, I carry it around everywhere I go.
And he's a single man now, ladies. Okay. So anybody who loves the bankruptcy code, you can...
All right. Thank you. All right. So there is this section. I'm not going to go through the whole thing because it's going to bore us all to tears. But basically, it's 11 U.S.C. 523. And then there's several enumerated exceptions. So basically, as I said, depending on the circumstances, you can file what's called an adversary proceeding. And I think we discussed this a few days ago, Joe. And
yes, in the context of some ongoing litigation.
Precisely. So if you receive notice that someone files for bankruptcy and you say, no, that's not going to fly with me for this reason, you can file an adversary. It's basically a mini lawsuit within the bankruptcy court that says, hey, I know that this dude filed for bankruptcy, and I know that he's trying to wipe out the money he owes me, but I don't think he should be able to for this reason, X, Y, and Z.
And let's just briefly back up. So basically, the notice issue is super important in this context.
Imperative.
If you get a bankruptcy notice, you've got to do something about it, okay? And basically, it's not always, it doesn't mean if they just send out the letter that you're therefore on notice. You've got to actually know about the bankruptcy or have received the letter. But basically, if you're a creditor, if somebody owes you money in a bankruptcy and you get one of these notices in the mail, you got to act immediately.
That's right.
And you got to call a lawyer right away, because otherwise you're going to lose your rights.
That's right. So that's correct, Joe. So generally what happens is if Joe Schmo consumer files for bankruptcy today, within roughly 14 days, every creditor will receive notice of the bankruptcy. And again, you have to actually list them. You can't just not list them and say, oh, I filed bankruptcy. Oh, well. But once you get notice, you can file an adversary proceeding. And again, there's a couple of exceptions. The main ones are basically like fraud, false pretense, false promise, embezzlement, that kind of thing.
Okay. So let's talk a little bit about a scenario where that might occur.
Sure.
So basically, when we're talking about fraud in the context of a bankruptcy, what are we looking for the creditor to have done?
Sure. So, it's imperative to analyze the facts between the debtor and the creditor in the totality of circumstances. And the main thing I look for with fraud is, did the debtor, and again, the debtor is the individual who's filing bankruptcy, the creditor is the person
collecting
to whom you owe money. So did the debtor at the time they incurred the debt know or should have known that they were fiscally insolvent? Did they know or should have known that there was just no way that they were going to repay the loan? For example, Joe, let's say I come to your office and we execute a promissory note. Okay, I'm down on my luck, and you loan me $1,000.
Okay.
And we have an agreement that says I agree to pay you X dollars a month until I pay the loan back. And then a week later, I file bankruptcy. Now, I'm not saying on the record, hey, I'm committing fraud, but you can tell from the circumstances. I knew or should have known at the time that I wasn't going to pay this loan back because of the proximity between the time that I acquired the loan and the time I filed bankruptcy.
Right.
So you should be able to prevail in an adversary proceeding, basically saying, hey, Max, you cannot discharge this liability you owe me. It's clear that at the time that I extended you credit, you knew you weren't going to honor this debt.
Right.
So that's the basic example.
Yeah. And then another interesting example in this context, especially in the business world, you're going to have corporate people that are trying to declare bankruptcy. And under Missouri state law, if you are a corporate office holder, you have a fiduciary relationship with the other members of the corporation.
That's right.
And this is another avenue to recover from somebody is basically, if they're not on good terms, if you are running a corporation and you are being false in your representations about the health of the corporation, or you're doing other acts that are causing grave harm to the corporation, then you can't use that corporate protection to escape the bankruptcy debt. Isn't that right?
That's correct. Under certain circumstances, you can, if you're able to prove embezzlement, breach of fiduciary duty, that kind of thing, then you should be able to prevent that person from discharging their liability as well.
Yeah, and you prove this at trial, right? So basically, what you've got to know in this business litigation context is if you've got somebody that owes you a lot of money and you get the right lawyer, you can put on a good trial.
Yeah.
You can win this type of case because the judge is going to be looking at the facts in question. And a lot of times the people that are defending the creditors, they're not going to have the litigation acumen to put on that good trial. And those are the types of situations that we really want to help. And basically anybody that's going through this bankruptcy process, you need some good help to get through it properly. And so over the next few podcasts, and we'll have Max back on and talk a little bit more about the bankruptcy litigation process and basically some tools that people can use in that context.
And if I may add one thing, because people always ask this. How much is this going to cost me? What about my attorney's fees, so on and so forth? Under the bankruptcy code, if you do prevail in your allegation of fraud and under certain types of other things like embezzlement, so on and so forth, you can get attorney's fees paid by the other side as well. So again, back to our initial example of you loaning me money. If I file bankruptcy and you file, and then you have to go and hire a lawyer and pay thousands of dollars for this lawyer to file this adversary, assuming that you prevail, then I'm the one that has to reimburse the attorney's fees as well. So that's just something to consider. It's not like all's lost forever.
Yeah, exactly. And so, if you've got to pay that retainer fee for the lawyer, there's a big upside to that, okay? Because you can end up getting the whole thing back at the end. So
precisely.
So we're also talking with Mark here. And so this is in the context of our entertainment litigation and entertainment services. And we provide full services to artists and record companies. And I have assisted record companies and artists in negotiating contracts and terms of engagement for the production of records and also for exiting certain record deals because these are always conflicts. And we're going to have artists on the show and talk with them about how to handle their business and that sort of thing. And so basically in this context, we have Mark as an expert resource because the intricacies of intellectual property law are always changing, and it's always good to have somebody on your team that knows really the ins and outs of this kind of stuff. So Mark, I understand you recently got published, isn't that right, on one of these topics?
All right.
Yes, Joe, that's correct. This recent article that I've been writing for past few months or past couple of months recently just got accepted for publication at the Wake Forest Journal of Business and Intellectual Property Law. We just received the offer about last night, and yeah, it'll be this article will be published hopefully in the summer of 2021 for
that's awesome. Congratulations.
Volume 20. Thank you for volume 20, I believe, of their journal.
So now it's on a real interesting topic, and so why don't you talk a little bit? What is the topic of the article?
So the article is called "With Eyes to See and Ears to Beer," and so it's basically this sort of play on words where we discuss this idea of multisensory IP. With regards to the craft beer industry.
So let's back up a little bit. So because we're trying to, and this is in the context, basically, what do you mean by multisensory?
So basically, we're dealing with intellectual property that deals with more, that really targets more than just one sense. And
Okay.
so this recent, and so basically, there's just a, you know, it targets more than just sight.
Okay.
It targets the sound, taste, scent. And so
Okay.
that's basically what we look at in terms of multisensory IP. And so, you know, several examples have been AI, cyber AI, and as well as perfumery and scents, because those and the key thing about these are they get tangled in more than just one discipline of intellectual property law. So, for instance, when you deal with perfumes, you'll usually end up dealing with maybe some patent, some trade secret, and then some trademark law. And then it's the same thing with this craft beer, this sort of multi-sensory craft beer. And so what really this paper talks about specifically is the idea of this sort of disciplinary science that was recently discovered in 2013 called gastrophysics, and which is basically the science of, well, food and the senses. And even more specifically is this idea is this concept called sonic seasoning, which is basically this sort of this technique that's kind of interesting in its way. It's basically the sort of what they call the crossmodal relationship between the food or the things that you taste and the sounds that you hear. So in layman's terms, what the hell does that mean? Well, basically, it's basically the foods that you eat or the beverages you drink can be affected by what you're hearing. So the music that you're listening to can basically alter the flavor of whatever you're tasting.
Wow, that's fascinating.
Yeah.
So it's
and
about
so
like
that
this
kind of intrigued me.
this interplay between basically you're listening, because just to back up a little bit, so basically intellectual property means that you create something and you own it, right?
Yes.
Basically, okay. And so basically
you own the idea. Yes.
Yeah, and so basically this what we're talking about is if you have somebody that is creating a perfume, and they create their own special smell in that perfume, that there's laws that allow them to protect their ownership of that perfume, right? So they have
That's correct.
Yeah, and there's different types of laws. So basically, the ingredients in the perfume are one type of protection, but you could also have a different type of protection in maybe a method that's used to assemble the perfume, right?
Yes,
and those are
that's
different
correct.
sort of domains. Yeah.
Right. That's usually where so several aspects that could come into play is trade secret, and that usually is the sort of recipe or the concoction of the particular perfume. But there can also be trademark aspects and how that perfume is marketed.
Yeah.
The sort of and so what we've seen here is really, you know, when you start having some of those that kind of, you know, get kind of blur in the middle between those two aspects, that's the most confusing part.
Yeah. So you're saying is the law doesn't know how to handle this right now, but you're
in some ways, yeah.
Yeah.
Yeah. Particularly with sonic seasoning. So the concept of sonic seasoning was actually discovered in 2016. What ended up basically what ended up happening was there a lot of gastrophysicists and a lot of scientists that wanted to discover the sort of connection between music and how to taste. Essentially how to taste music. What does music taste like? Can genres of music, can tonalities or timbres of music, can they affect the way that you taste something?
Okay.
And so there was an experiment. I want to say it was in either in Belgium. I want to say it was in Brussels to be exact. And they created they did this sort of experiment where they had this brewing company, this microbrewery there in Belgium, created a particular beer that was inspired by a UK indie rock band called Editors.
Okay.
And they had they were coming out with a 2017 they were coming out with a 2017 album. And they wanted to create this sort of beer to complement the way that their album sounded. And so they came up with, particular Earl Grey tea flavors, particular blends, processes, etc. And they did this experiment, and they found that that there was a difference. There's a change in the way that people reacted to this beer when they listened to this music versus when they didn't listen to anything, when it was just a natural environment. Now, they believe that some of this effect can be more to, people's music preferences, essentially. And that kind of makes sense because not everybody knows who Editors is. Some people might be more familiar with their music. Others may not be. Others may not really care for, that particular music, but it kind of makes sense in a way, because
so can the band owner sue them for that, or if they're making the beer based on the band, and do they have a licensing, or how does that work?
Well, that's kind of interesting because usually I would think when you start getting into that, then usually there usually would be an agreement in between as far as who owns the music versus who owns the beer. As far as the beer particularly being a music composition, this is where
over 5 minutes.
This is
just over 5 minutes.
This is where usually it starts getting a little bit difficult because a craft beer is not really a copyrightable work.
Right.
But
maybe the list of ingredients though fixed in a tangible form, and then the components of the beer are a trade secret.
True. But usually that's usually with the brewery. At the same time, though, can the
band own that impression of the music into the beer, that affect, that phenomena of hearing? And just so you know, Mark, we've got to be done in about 2 minutes. So that's your final question, and then I've got one more question for Max. So
I know this is completely a very intriguing and wild off the topic subject. It's very complex, but usually with the music, as far as the blend and the notes and all that, usually that's not really fits in those kind of ingredients are not really something we would think about being in an intangible medium in terms of copyright law. Usually that's kind of separate in itself. And I advocate basically that when it comes to microbreweries and wanting to create, this sort of, redesign their brand, especially with COVID-19. A lot of breweries have been struggling.
All right, we've got 1 minute. 1 minute.
Since the coronavirus. But
bring it home, baby. Bring it home.
I advocate that they bring in trade dress to basically protect their work.
Okay.
Because trade dress there is the overall feel.
Okay. And Max, would that be an asset in their bankruptcy?
Absolutely, it would be. I mean, it's something that you can take, you can liquidate, you can turn into cash, you can sell it 100%.
Liquidate? Okay.
No pun intended.
And now it's 5 p.m., so we may liquidate this meeting.
Right.
And but you have a right as a listener to reconvene and hear it a little bit later on, and we're putting you on notice of that.
Let's go get some craft beer.
So we may do that. But okay, guys, it was great having everybody on the show today, and just tune in and next week. And if you want to ask me any legal questions whatsoever, you can at any time. Call my law firm, 314-293-3756, or we're at ott.law. What's your website, Max?
Grosswaldlaw.com, GROSWALD law.com, 314-736-1275.
Okay. All right. Thanks, guys. We'll see you later.